Attention gun owners. A historic Supreme Court decision just landed, and it affects every single person who owns, carries, or plans to buy a firearm. This isn't a close call ruling that split the justices down the middle. Every justice agreed. That almost never happens. And when it does, it means your rights just shifted in a major way. If you own a gun in any state in this country, you need to understand what just changed before you make another decision about where you carry or how you store your weapon. Let me tell you about Thomas. He's 72 years old and lives in Charlotte, North Carolina. He's had a concealed carry permit for 11 years without a single problem. Last spring, he was stopped by a local officer while walking through a city-owned greenway trail. He had his legal firearm on him. He thought he was following the rules, but a local ordinance said that greenway was a restricted zone. He didn't know that ordinance existed. The case is still unresolved, and it's cost him nearly $4,300 in legal fees so far. That story is exactly why this Supreme Court ruling matters so much to you personally. The rules are changing, and the direction they're changing is actually in your favor, but only if you know what's happening. Keep watching, because I'm going to break every piece of this down in plain language. Before I get into the full breakdown, let me ask you something. Are you subscribed to this channel? If not, here's the honest truth. Subscribers are the people who actually catch these updates in time to act on them. Non-subscribers find out weeks or months later when it's already too late to respond. Legal landscapes shift fast. I release updates the moment major decisions drop. You don't want to miss the next one. Hit that subscribe button right now before we go any further. Now let's talk about what the court actually decided and why it matters so much. The Supreme Court just handed down a ruling that changes the entire framework courts must use when judging gun laws. Every state in America is now required to meet a specific two-part standard. First, any gun restriction has to line up with the actual written words of the Second Amendment. Second, and this is the part that's shaking things up, the state has to show that the restriction matches a real historical tradition from the founding era of this country. That second requirement is the game changer. For years, states could pass gun restrictions simply by arguing the law made communities safer. That argument was often enough to get a law upheld in court. Courts would weigh the safety benefit against the burden on gun owners and often side with the state. That approach is now off the table. Safety arguments alone don't cut it anymore. The state has to open a history book and prove that people in the late 1700s would have recognized that kind of restriction as acceptable. Think about what that really means. Most modern gun restrictions were written in the 1980s, 1990s, and 2000s. The people who wrote those laws were thinking about modern crime statistics and public health arguments. They weren't thinking about whether a blacksmith in 1793 would have agreed with the policy. So now legal teams across the country are going back and reviewing dozens of laws through this brand new lens. And a lot of those laws are not holding up well under that scrutiny. Let me give you a concrete example so this clicks. Imagine your state passed a law in 1997 saying you can't carry a firearm within a certain distance of any municipal sports complex. When that law passed, the state argued it reduced the risk of confrontations at public events. Under the old system, that argument could work. Under this new ruling, the state has to show there was a tradition of restricting firearms near public gathering spots in the founding era. That's much harder to prove, and if they can't prove it, the law could be struck down. Quick pause right here. What state are you watching from? Drop your state name in the comments section right now. Gun laws are dramatically different depending on where you live. I want to know where my viewers are located so I can cover the states that matter most to you. Your comment also helps push this video to more gun owners who need this information. Type your state below right now. Let me tell you about Barbara. She's 69 years old and lives in Portland, Oregon. She applied for a concealed carry permit 3 years ago after a series of break-ins in her neighborhood. Her application was denied. The reason the licensing office gave her was vague. They cited concerns about her temperament based on a neighbor dispute from a decade earlier. She had no criminal record, no restraining orders, nothing that would normally disqualify a person. But the state had discretion to reject permits based on broad subjective criteria. After the denial, Barbara appealed twice. Both appeals were rejected. She hired an attorney who told her that under the previous legal standard, the state's discretion to set those kinds of requirements was likely constitutional. She spent over $5,800 fighting the denial and eventually gave up. She still doesn't have a permit. But here's what changed. The new Supreme Court ruling makes laws that rely on vague or subjective permit criteria legally vulnerable. Her attorney has already contacted her about reopening her case. Barbara's situation is not rare. Across the country, thousands of law-abiding gun owners have been denied permits or faced restrictions based on standards that were never grounded in constitutional history. Those people now have options they didn't have before. If you or someone you know was denied a permit, and the reason wasn't tied to a disqualifying criminal record, it may be worth a second look with an attorney who knows this new legal landscape. Now let me address the states where this is going to hit the hardest and fastest. If you live in Colorado, Washington, Oregon, Maryland, or New Jersey, your state has some of the most legally exposed gun restrictions in the country right now. Many of those restrictions were built entirely on public safety arguments. They look good on paper, they sound reasonable, but they don't have deep historical roots. And that's the standard that now controls everything. Here's what's already happening on the ground in those states. Legislative staff are quietly reviewing laws that were considered settled. Some lawmakers are already signaling they may not fight certain legal challenges because they know the cases are weak. In a few instances, enforcement of specific restrictions has been paused while state attorneys assess whether defending those laws is even worth the effort. You're watching the beginning of a major shift in how gun rights work in America, and it's happening right now. Let me tell you about Richard. He's 74 years old and lives in Indianapolis, Indiana. Indiana is actually a state with relatively fewer restrictions compared to the ones I just mentioned, but Richard ran into a problem with a specific local ordinance, not a state law. His city had its own rule about carrying firearms inside any building that received city funding, which included the library, the community center, and several parks with public restrooms. That list was broader than most people realized. Richard carried legally into the community center for a senior fitness class. He wasn't aware the building fell under the city ordinance. He was asked to leave and then cited. The citation led to a hearing. He wasn't arrested, but the process cost him time, stress, and $2,100 in legal consultation fees. The charge was eventually dismissed, but the experience rattled him. He told his attorney he felt blindsided by a rule nobody had ever explained clearly to him. Here's the lesson in Richard's story. Even in gun-friendly states, local ordinances can trip you up. And under this new Supreme Court framework, local ordinances are just as subject to the historical test as state laws. Cities can't just create their own gun-free zones based on convenience or funding arguments. Those ordinances now have to meet the same historical standard. Local legal challenges are going to multiply over the coming months, and Richard's experience is exactly the kind of situation that may soon be protected. If you're getting real value from this breakdown, do me one favor right now. Hit the like button. I know that sounds like a small thing, but it genuinely matters. The platform's algorithm decides who sees this video based on how many people engage with it. When you like this video, more gun owners find it. More people who need this information get it. That literally takes 2 seconds, and it helps protect more people's rights. Like the video right now, and then keep watching. Now let's talk about something that most gun channels aren't covering. This ruling doesn't just affect carry laws. It reaches into other areas of gun regulation that you probably haven't thought about. Background check procedures, waiting period laws, storage mandate laws, and restrictions on specific firearm features are all now subject to the same historical analysis. That's a much bigger set of laws than most people are tracking. Take waiting period laws as an example. Several states require you to wait between 3 and 14 days after purchasing a firearm before you can take it home. The historical justification for that kind of restriction is thin. In the founding era, you bought a firearm and you walked out with it the same day. There was no equivalent waiting period tradition. Legal teams are already looking at these laws with fresh eyes under this new standard. The outcomes of those challenges could affect millions of gun buyers. Let me tell you about Nancy. She's 71 years old and lives in Louisville, Kentucky. Kentucky is a fairly gun-friendly state, but Nancy was traveling and found herself briefly passing through Illinois on a road trip to see her grandchildren. She had her legally owned firearm with her. She was fully compliant with Kentucky law, but Illinois has some of the strictest transportation rules in the country. She didn't know the specific requirements for transporting through Illinois. She was stopped at a routine traffic checkpoint near the state line. She told the officer she had a firearm in the vehicle. What followed was a 2-hour roadside stop, a vehicle search, and a citation for improper transport under Illinois law. She was not arrested, and the charges were later reduced, but the experience scared her deeply. She told her daughter she felt like a criminal for following the law she knew. She spent 4 months dealing with the legal aftermath, and it cost her $3,750. Nancy's situation highlights the danger of not knowing how drastically laws change from one state to the next. And here's the critical connection to the new ruling. Illinois transportation and carry restrictions are among those being reviewed right now under the new historical standard. Legal advocates are challenging the specific rules that caught Nancy off guard. If those challenges succeed, the law she was cited under may no longer exist in the same form. But right now, it still does. And that's the part you have to be careful about. Think of someone you know who carries a firearm regularly, a family member, a friend, a neighbor, someone who might not know that the rules just changed in a major way. Share this video with that person right now. Don't wait until after the video ends. Text them the link while you're watching. They need this information and you have the power to get it to them. Share this video right now. Now let's talk about the federal angle that most people are completely ignoring. This Supreme Court ruling doesn't only apply to state laws. Federal gun laws are governed by the same constitutional framework. That means federal restrictions are also subject to the historical tradition test. Federal laws restricting certain firearm features, certain ownership categories, and certain locations are all now under the same legal microscope. We could see challenges to federal laws that have been untouched for 30 or 40 years. Here's what that means for you in real terms. If you've been told you can't legally own a specific type of firearm under a federal rule, that rule may now be legally vulnerable. If you've been subject to a federal restriction that didn't exist in any form in the founding era, there may be a legal pathway to challenge it. This is evolving territory. The cases will take time to work through the courts, but the direction of the law has clearly shifted. Now here's exactly what you need to do. I'm giving you 5 steps. Each one is specific and manageable. You don't need to complete all of them today, but start with step 1 this week. These steps are about protecting yourself right now while the legal landscape evolves. Write them down. Ready? Let's go. Step 1. Find out the exact gun laws in your state and your specific city or county. Don't rely on what you heard from a friend or what you read on a forum 2 years ago. Laws have changed. Local ordinances may be different from state law. Go directly to your state's official attorney general website or your state legislature's website. Search for your state's firearm statutes by name. Print or save them. You need to know exactly what is legal where you live and where you travel. Do this before the end of this week. Step 2. Look up whether any gun laws in your state have recently been challenged in court. Search your state name plus the phrase Second Amendment Legal Challenge 2025 or Gun Law Lawsuit 2026. You will likely find news articles about active cases. Understanding which laws are being challenged tells you which rules may change soon. It also tells you which restrictions to be especially careful about right now, because courts may currently be deciding whether to enforce them. Knowledge of active cases is power. Step 3. If you carry a concealed firearm, review your permit's specific conditions right now. Many permits come with conditions listed in fine print that permit holders never fully read. Some permits restrict where you can carry even within the state. Others have requirements about how the firearm must be stored in a vehicle. Read every line of your permit documentation. If anything is unclear, call your state's licensing office and ask directly. It's better to ask a question than to unknowingly violate a condition and face a citation. Step 4. If you travel between states with your firearm, learn the laws of every state you pass through, not just your destination. Every state you drive through counts. Use a legal travel resource such as the Traveler's Guide to the Firearm Laws of the 50 States, which is updated annually by a licensed attorney. This resource is available online and in print. It gives you state-by-state rules on transport, carry, and storage. Carrying without knowing the laws of every state you travel through is one of the most common ways legal gun owners get into serious trouble. Step 5. Consider scheduling a one-time consultation with a firearms attorney in your state. This doesn't have to be expensive. Many firearms attorneys offer a flat-rate consultation for 1 hour. In that hour, you can get a complete picture of how the new Supreme Court ruling affects your specific situation, which local laws may be changing, and what steps protect you best. Search for a firearms law attorney in your city plus your state name. Look for someone who specifically lists Second Amendment or firearms law as a practice area. One conversation could save you thousands of dollars and enormous stress. Step 6. Stay current by following reliable legal news sources that cover Second Amendment developments. Look for newsletters or YouTube channels run by licensed attorneys who track court decisions. When new rulings come down at the state or federal level, you want to know within days, not months. The legal landscape right now is changing faster than most people realize. Being among the first to know protects you in a way that nothing else can. Let's review everything we covered. A landmark Supreme Court decision just changed the standard every state must use when writing and defending gun laws. States can no longer rely on public safety arguments alone. They have to demonstrate that any gun restriction has roots in the historical tradition of this country going back to the founding era. That standard is a high bar. Many existing laws don't meet it. Thousands of legal challenges are already working through courts across all 50 states. Some laws that have been on the books for decades are now vulnerable in ways nobody expected even a year ago. The people who get caught off guard by this shift are the ones who assume nothing has changed. They keep following rules that no longer exist, or they unknowingly violate rules that are still being enforced while a challenge works through the courts. Don't be that person. You now understand more about this ruling than most gun owners in America. That knowledge is genuinely valuable. If this video helped you, here's what to do next. Subscribe to this channel so you don't miss the next legal update. Share this with a gun owner you care about. Drop your state in the comments so I know where my viewers are located and so I can create content that speaks directly to your situation. I read comments and I do respond when I can. Your engagement also helps the platform show this video to more people who need it. Important disclaimer. Everything in this video is for educational purposes only. Nothing here is legal advice, and nothing should be treated as legal advice. Gun laws differ dramatically from one state to another, and they are changing rapidly right now. Before you make any decisions about how you carry, where you carry, how you store your firearm, or whether to challenge a legal denial, consult a licensed firearms attorney in your state. What applies in one state may not apply in yours. Always get qualified professional guidance before taking legal action of any kind.